Orange case, the question really was, let me repeat.
Injured.
That's an interesting.
Kid who
right.
had been injured in the system, come back at age 18 and do one of these cases.
Okay, let me repeat it just so everybody back there can hear it. And if I get it wrong, just tell me. Basically, the question, although it derived from the Hardwick versus County of Orange case, the question really was, in that circumstance where we have a child that then turns 18 and pursues their rights, how do we go about stacking that with the parent, or how does that interplay with the parent's claim that the parent might have brought before? Did I get that more or less right?
If the parent was not able to meet the statute
right.
That when the kid turns 18, it's his case.
Right. So it's essentially whether or not the parent brought it before, how that interplay goes. First of all, that's 2 or 3 questions on the same thing, but I'll answer all 3 because they're all related. First of all, we've already addressed a little bit the statute of limitations. I don't know if we covered what happens with a child that reaches the age of majority, but when they turn 18, they have an independent right, separate and apart from their parents, to pursue their federal claims. With respect to the state claims, different states do them differently. In California, if one of the parents, either one, got the kid back, at the point they got the kid back out of county custody, they had 6 months to file their tort claim. Otherwise, all the state law-based claims are blown out. And typically, where you have a situation where there's strife between mom and dad, let's say, for example, dad gets the kid back, dad's not going to go pursue anything. So the kid's basically stuck just with their federal claims when they turn 18. The statute of limitations, again, is 2 years. They have until their 20th birthday. This is California, different states, different statutes. But they have till their 20th birthday to get their federal civil rights suit filed. Now, in the circumstance where you have a parent who maybe blew their statute, didn't get it filed, their kids now turn 18, whatever happened with the parent in relation to losing their claims has no impact on the child. So if the parent didn't meet their statute of limitations, doesn't matter at all. If the parent filed a case and lost, it doesn't matter at all. Now, there's an interesting circumstance when the parent filed their case, won, and now the child years later wants to sue. And this sort of comes into where I was talking about how we sit around at my office all day and just dream up ways to go attack the government. This is one of them. So you have a situation, this is the Hardwick case. Have a situation where you have a parent who brought their case based on judicial deception, won at the trial court level, won on appeal, went all the way to the U.S. Supreme Court, won all the way up. Now, years later, her daughter comes back and is suing for the same thing. The same lies caused me to be removed from my mom for 7 years, and here I am for compensation. Okay. The approach on that, and it's kind of a bummer because I actually filed that case. I filed Deanna's case, filed Presley's case, filed Kendall's case, all of them. And there got to be some issues later on in the development of the litigation. Conflicts came about, and I ended up stepping out of the case. Thankfully, Bob Powell, he's another one of the Gang of 8 in California that does this work. I call him up and say, hey, dude, I got a problem, and nobody else can really handle the work because, these are complex things, and that was especially complex. So he said he'd come in and take it, and he did it. And he took my summary judgment motion on collateral estoppel, filed it, and won. And then the county, I have mixed feelings about it, whatever. But the county then appealed it. So that's how it got up in front of the Ninth Circuit, is the county complained that, hey, this collateral estoppel thing, it shouldn't work here because we had qualified immunity. And what the appellate court did in the Ninth Circuit is they said, well, we don't even have to get to the issue of collateral estoppel because any idiot on earth would know that you can't lie. So that was the overall outfall of the Hardwick case, but it answers your question. that whatever happens with the parent in their situation has zero impact on the child's rights unless the parent wins, then you can use what's called offensive collateral estoppel to limit the amount of proof you're going to have to bring in front of the court in the child's case. So I think that answers your question.
Thank you so much.
All right, let's just do like one more or something, then we're going to get rolling out here. Go ahead, Scott.